All right, you must be Arletris Carter, is that correct?
Sure.
Ms. Carter, my name is Robert Ramsay, I'm the Judge or Magistrate for Denton County. So unfortunately, it looks like Dallas County has confirmed on a warrant out of Dallas County. The good part of that is they might just be trying to clear everything up and give you credit for the time you've been here. So it's Dallas County Warrant M20168449M, original charge of criminal trespass, which is only a Class B misdemeanor. Does have a new bond set, and it's an INSBD, which means they hold your bond to be insufficient. But I would imagine what they're really trying to do is make sure that you get credit and get this behind you so you can just take care of it with the time that you've been here as well. You certainly still have all your same constitutional rights. You still have the right to remain silent. You don't have to talk to police at all. Anything you say can probably would be used against you later on. So you still want to be careful what you say. If you start to make a statement to the police, you can always stop at any time. You don't have to continue to talk. Have the right to speak with an attorney. Have the attorney present any question. Have the attorney represent you at trial. And if you couldn't afford an attorney, then Dallas County would appoint and pay for an attorney for you on this charge. And you certainly still have the right to a trial by judge or jury. Just because you're charged doesn't mean you're guilty. Do you understand all those rights, Ms. Carter?
Yes, sir.
Without saying you agree with it, just that you understand your rights, your charge, your bond. Let me get your signature on this line right here. It's just saying you understand your rights. You're not saying you agree with it. And the good news is it looks like we've taken care of all your Denton County cases, so Denton County has no other holds. So we'll tell Dallas County to come get you, and imagine what they're going to try to do is get you down there, take a plea, and then give you credit for the time that you're up here as well, okay? Let's try to get you a court-appointed attorney as well. So let me get your initials. There's a box on that same sheet. The lower box, the one that's closest to your signature, says, "I am indigent," and ask you for court-appointed counsel. All right, we'll get that set up for you so that we can get you on your way, and hopefully we're going to get all this stuff taken care of for you, okay? All right, thank you. I think they want you to go with them now. All right, folks, for everyone else, my name is Robin Ramsay. I am a magistrate or associate judge for Denton County. So part of my job is just to tell people what they're charged with, make sure they understand their rights, tell you how much bond's going to be. Good number of you have been here for some time, and these are just other cases that popped up. So this is not going to be anything new or different. It is a matter of record, so we are recording it for the purpose of a record of the court, but also to that extent, you still want to be careful what you say because it could be used against you later in another hearing. Other than that, you can post the bonds if you have bonds available. Several of you have a no bond status. We're going to go over that individually, but if you have bond, you can post that bond in order to secure your appearance out of court, out of jail. Just make sure you make your court appearances once you post that bond, because if you don't come back for court when they tell you to, they'll issue another warrant for your arrest and it'll start all over again. On the other hand, if you're here on other cases, sometimes your bond's going to go off your bond, or they're simply holding your bond insufficient so we can get you credit to run concurrently. If you're out on bond and you get rearrested, then typically that time that you're here doesn't apply until you're off, until the bond's no longer there. So that might be the case in a good number of your cases here today. Other than that, though, each of you here absolutely still have constitutional rights. You still have the right to remain silent. You do not have to talk to police at all because anything you say can and probably would be used against you later on. So you still want to be careful what you say. If you start to make a statement to the police or anyone representing the state, you can always stop at any time. You don't have to continue to talk. You have the right to speak with an attorney, have an attorney present during questioning, have the attorney represent you at trial. And if you cannot afford an attorney, Denton County will appoint and pay for an attorney for you, or if it's a warrant from a different county, that county will appoint and pay for an attorney for you if you're claiming to be indigent and if you are indigent. Indigent, of course, meaning that you don't have a job, source of income, family, friends. You don't have any way by which you think that you can afford to hire your own attorney, or from a practical standpoint, post your bond. So if you're sure that you're not going to be able to hire your own attorney because you don't have job, source of income, or anybody who's going to help you with that, then if you indicate that on this form here today, claiming to be indigent, we'll begin to get our process started to get you a court-appointed lawyer. If you've already had an attorney appointed on other cases, we typically appoint the same one so they can kind of bundle them all up and take care of them at the same court hearings. But if not, we'll start the process to get you a court-appointed attorney. Just make sure that you fill out any affidavit or statement regarding your financial status to be full and complete, and truthful, because if it's not, they could charge a separate offense of perjury. But if you qualify and the county finds that you're indigent, we'll appoint or assign you a court-appointed attorney if you don't already have an attorney, or if you do have an attorney, we'll appoint that one as well. If you're here on a warrant from a different county, you're claiming to be indigent, we'll notify that county electronically of your claim so they can begin to get their process started to get you a court-appointed lawyer. Although you normally won't be talking to a court-appointed attorney on a case outside of this county until you've been transferred into their custody. If you're here for a felony grade offense, you're unable to post your bond after a reasonable period of time, and the case has not been indicted, then you can also ask court to release you without posting bond at an examining trial. And even if you're here for a Class B misdemeanor for more than 15 days, more than 30 days on a Class A misdemeanor, or 90 days on a felony, if the case still has not been filed and presented by the district attorney's office, then you're entitled to a request to release on a personal bond. Last, but certainly most importantly, you absolutely still have the right to a trial by judge or jury. Just because you're charged and arrested doesn't mean you're guilty of anything. You do have a right to a trial, but you need to post your bond in order to get out of jail prior to going to trial. Does it sound like I've had a lot of coffee today? So let's start off with Richard Mitchell. Mr. Mitchell, come on up. Mr. Mitchell, they have you here on a charge of lesser included offensive assault. Kind of strange how they put that, out of 211 District Court Warrant F21 230 211. No bond currently doesn't mean you can't get a bond set. The original charge of assault on a pregnant person, but it looks like they may have indicted as, oh, it's a motion to proceed adjudication guilt. So again, the good news is it's not a new case, and even better news, you might be able to get a bond set, but it's going to be up to Judge Shanklin to do that for you. So let's get your signature on that line, just saying that I told you about this case and a motion to proceed adjudication of guilt. How long have you been in custody? You turned yourself in, right?
Probation violation, I think.
You have an attorney, Mr. Mitchell?
Not at this time. For what charge? I mean,
Well, you have this charge. Your attorney's going to have to go and see Judge Judge Shanklin to get a bond set for this. Do you have an attorney?
not at this time.
Are you able to hire an attorney? Because it might be a little bit faster if you did.
Sir?
Are you able to hire an attorney? Because it'd probably be faster if you could hire your own attorney. But if not, we'll try to get you a court-appointed lawyer.
Your Honor, I'm in prison. I'm in jail right now. So I have a job. I have work, but in this situation I'm in, I can't say I'd be able to.
Okay, well then let's try to get you a court-appointed lawyer. So initials in that bottom box. So did you turn yourself in the front lobby?
Yes, sir.
Well, that's going to help get you a bond set, but it would have been better if you'd had an attorney so that they know to go over there as soon as you turn yourself in, try to get a bond set for you. So
My probation officer, Mrs. Rodriguez, sent me a note saying I have a warrant for my arrest.
and she was right. Okay.
About it, and I just turned myself in. So
Okay. Well, we'll try to get you lawyers so they can go get a bond set for you. Okay. All right. If you give me your signature and your initials in that bottom box, have a seat. We'll try to get you an attorney appointed. Okay. All right. Thanks. Alexandria Gord Gallegos. All right. One charge, possession, controlled substance, group 2, under 1 gram in amount. Again, it's a no bond allowed. It's a failure to appear. They claim you failed to appear for court way back on January 23rd of 2020. So it is possible to get a bond set, but I cannot do that for you. You're going to have to get Judge Shipman of the 16th District Court to do that. So again, just saying you understand your rights, your charge, your bond without saying you agree with it or admit guilt. Let me get your signature on that line, just saying you understand your rights, your charge, and your bond. And do you think that you can afford to hire an attorney? Because it would be faster to go get a bond set for you. If not, we'll put in a request for a court-appointed lawyer. Are you asking for a court-appointed attorney and claim to be indigent? I'll take that for a yes. And just give me your initials in that bottom box saying you're claiming to be indigent. All right, we'll try to set up and get you an attorney, okay? All right, thank you. Um, David Bentlich. David, how you doing?
Good. Ramsey, how you doing?
It's always good to see you again. Welcome home.
Yeah, clearly.
Yeah. So apparently your bondsman is upset with you. Why would that be, David?
Because they never went off my bond. I've still been on.
Oh, they did now.
Yeah, well, I thought you took care of this last time I seen you.
Oh, David, you know I make empty promises.
Uh,
So actually, these were issued out by the judge of the court. So these are about November the 8th. These were done yesterday. Wow. Yep, they were issued yesterday. So $1,500 went to 15, 17, 16, charged out of the 158 district court. So this one's going to be in Judge Burgess's court, F21 to 2984 for possession controlled substance pen group 1, again at 2,500, and possession controlled substance pen group 2 under 1 gram, also 1716 MC 210485 at $1,017.16. So that would bring your grand total up to about $4,500 or just a few dollars more. So they're bondable again, David, but bonds will probably run you about $500. You gonna try to bond out again?
I got a marshal hold, so I'm not going
Oh, yeah. What was I thinking? It's kind of a tease,
anywhere.
huh?
Is this for 3 or 2?
3 of them, possession controlled substance, and surprise, surprise, possession controlled substance. So signature on that line, just so you understand the information, David. You have a federal marshal's hold?
Yes.
Oh, David, the feds don't play.
Yeah, I know.
And then initials in the top box, bottom box, so we can get you a court-appointed lawyer. Do you already have an attorney, David?
Yes, Robert John Holland for my state, and then Ralph De La Garza for my U.S.
Okay, they'll probably, the county likes to defer to the feds, but good luck on that, right?
Right.
All right, David, well, have a seat. We'll try to get you a record, and sounds like I may not be seeing you for a while, huh?
Good seeing you again.
Somehow that's both reassuring and disturbing at the same time. Doing kite, sorry. It is pronounced kite, is that correct?
Yes, sir.
So you have 2 that are 1716s and one's an FTA, the one MC 21040551 at 1,017.16, charge of indecent exposure, and then a second FTA or failure to appear out of county criminal court number 4. It's possible there's the same charge, but right now I can't tell. So warrant CR 2021-03669-D has a cash only bond out of county criminal court number 4. So it's a total then of $4,017.16, but $3,000 would have to be in cash, but they're bondable. So if you have a friend that has like $4,000 sitting around somewhere, that would get you out. Without saying you agree with the order, let me get your signature on that form, just saying you understand rights, charge, and bond. And do you have an attorney on these cases, Mr. Kite?
No, sir.
Do you have a job, source of income, or family or friends are going to try to help hire an attorney for you?
I just started a new job when I got locked up.
Well, that's not going to impress your boss. So let's try to get you a court-appointed lawyer. Then initials in that bottom box right above your signature, so I can try to get you a court-appointed attorney. We'll see if we can get one appointed in the next couple of days. And they might come over here and see if they can get that cash bond changed into a regular bond. Okay?
Yes, sir.
All right. Thanks. Have a seat, or go with them, whichever. James Sexton. Hello, Mr. Sexton. Charge of fraudulent use, possession, identifying information, less than 5 items out of the 211th District Court. 211, all right, it's warrant F21, 3139 at 211. Bonds only at $1,000, but it would have be in addition to your others, including a no bond on a violation of protective order.
Do you know why that one has a no bond on it by chance?
Yes, it's a violation of protective order. It is filed in the 431st District Court, so it's probably assigned to 362nd. Do you have an attorney yet, James?
Yeah, Derek and Nami, I'm on probation for all those other violations or for all those other charges. They're just a motion to adjudicate guilt and motion to revoke.
Mr. Adami may actually be trying to get all these taken care of at the same time. He's a very good attorney. So talk to Derek. He knows what he's doing.
Okay.
He's probably trying to cut some deal where we can take care of everything, so you don't have to keep coming back.
Yeah, I have almost a year back time at this point. So.
Yeah, it sounds to me that's what he's probably trying to do. But again, talk to Mr. Dami. He would have the inside part of that story. So
Okay.
let me get your signature on that form, just saying we talked about this charge being active again.
Yeah, it's crazy how they came and sent me my indictment papers before I got arraigned for it today. So.
Yeah, and it is does have a capious form of indictment. And then initials in the top box, you retain Mr. Adami, right?
No, I was for, he was court appointed.
Oh, wow. Okay.
Yeah.
And then initials in the bottom box.
Okay.
Perfect.
Yeah. Yep. All right. Thanks. John Hartung III. Mr. Hartung, 2/17/16. So again, these are not new cases. They're old cases. What happened is when you got rearrested on all those charges out of Flower Mound. Damn, did they set some high bonds or what?
It's going federal, or one of them is apparently, that's what they said.
Okay, so what happened was then your bondsman took that opportunity to go off these bonds. So these aren't new cases, they're old cases, but you would have to post new bonds. Good news is I only increased them by $17.16, so I know that they're reissued warrants. Possession controlled substance PG1, MC 21-10066 and 10068. Each one, first one's 2,517.16, the other one's 1,517.16. Second charge is a tampering charge. So do you have an attorney?
McMyers
And is he court appointed or did you hire Mr. Meyer?
hired him.
Initials in the top box saying you have your own attorney. He's also a very good attorney and not exactly what you call Mr. Touchy-feely when it comes to conversations, but he's a very good attorney and takes care of business.
Yes, sir.
All right, we'll let him know. Thanks. Jason Smith. Mr. Smith, one charge of assault, family violence with a previous conviction out of the 211th District Court. Again, it's not a new case. It's just where your bondsman took this opportunity to go off your bond. Wow, did the judge and didn't set some high bonds or what?
Yeah, they did.
Possession controlled substance peer group 1 at $250,000. Wow. So this one is only a $10,000 charge of family violence with a previous conviction. So it is bondable again, but it would be in addition to everything else. Warrant F20 1920431. Again, it's just where your bonds went off your bonds. So let me get your signature on that form, just saying you understand your rights, your charge, and your bond. And do you have an attorney already, Mr. Smith?
Yes,
Is it court appointed when you hired?
I hired him, Dominic Marsalis.
Very okay. Get hold of him. He'll see if he can file a motion to get that other bond reduced. Because
That's what I'm working on right now.
that is a smokingly high bond. So initials in the top box if he's hired.
That's what I'm working on now, trying to get a bond reduction.
All right. Thanks.
All right.
Michael Petty. Mr. Petty, it is a driving while intoxicated, but it's not a new case. It's not even a case that you haven't been adjudicated. It's a probation violation. So it's an MTR, standing for motion to revoke probation, out of the 462nd District Court. Warrant F20 1721211. So I don't know the reasons for the probation revocation, but currently has no bond. It's probably because you're charged with other offenses as well. So you would have to have your attorney contact Judge Shanklin and the 211 to try to get a bond set for you. So you have those other two at $5,000, $2,000, so $7,000 in bondable amounts. But until you get this bond set, it really wouldn't do you any good. So let me get your signature on that line, just saying you understand your rights, your charge, and the fact that this case has been reactivated. And then your initials. And do you have an attorney?
Yes, Your Honor.
Is it court appointed when you hired?
Court appointed.
Initials in the bottom box. Do you know your attorney's name?
Not right offhand.
It's Michael Dance. So we will notify Mr. Dance that you've been that you're here and see if he can take care of this one at the same time. Okay.
All right, thanks.
All right. Thank you. Austin Madewell. Mr. Manuel, one charge of possession of controlled substance, pen group 1 to 4 grams. It's a at-large warrant, DCMAG 20 ALW-066. Because you, looks like you turned yourself in, is that right? No, they came to your house.
Right.
I set the bond very, very low on this because I read the affidavit and I thought, I just wish you get help instead of something else. So.
Right.
Bond's
And
only
I've,
1,000.
I've gone to rehab and I'm sober. I've been sober ever since October of last year, and I'm doing very well, sir.
You're not doing very well?
No, I'm doing very well.
Okay, good. Well,
Yes.
that's why I did reduce the bond, because typically these are 5,000 to 10,000, but your bond's only to 1,000. So bonds running you maybe $175, $200 to get you out.
200?
It's typically a bondsman charge you usually about 10%, but that's such a low bond, they charge about 20%. So it's usually around $200.
Well, thank you so much. I was gonna tell you this year's been really rough. I just lost my father a couple months ago, and my mom works for the federal government and she doesn't make a ton of money, and I detail cars for a living, and I don't make a ton of money, and we live on a big farm, and it's, finances are kind of tough, so I really appreciate that.
Well, as a matter of fact, do you have a risk assessment? Look at that. No assaultive offenses. How many times have you been arrested? It would seem to me to be the kind of thing one would remember.
Well, I've been arrested for controlled substance back in 2012. And then I've been arrested for some theft charges a long time ago. I can't remember when, but I think they're expunged off my record now. It's been so long. I did probation for them out of Denton County years and years and years ago. So I'm not sure.
Based on the facts, the only reason they came to the house was that they called because you were having a medical crisis from taking the drugs. So
Right.
I'm going to give you a personal bond.
What's that mean?
That I'm stupid.
Oh, don't say that.
It means you're not going to have to pay any money.
Okay.
You're going to be released on a promise to come back to court when you're told to do so. Make sure you put down a good, solid address. But again, my reason for doing this was, were it not for the fact that they were called out as an emergency to give you medical services, they wouldn't have found the drugs.
Right, right.
So it means that you're going to sign a piece of paper, promise to come back when they tell you. Make sure you put down a good address, because that's where we're going to send your notice of court. If you don't come back for court, they'll come rearrest you.
Yes,
and,
sir.
And then there'll be a very high bond.
Yes, sir. You have my word. I will show up at court.
All right, then give me your signature on that, and then your initials in that top box saying that you're not claiming to be indigent, because I'm going to get you out on a personal bond.
Okay.
Know when you're out, Judge, so I can reprint.
Okay.
And will I be released from Denton County today?
Yes.
Okay. Thank you so much.
Okay, I'm out, Angela.
Thank you very much, Judge. You have no idea how much that helps me and my family.
And and I want to be honest with you, I don't want to punish people. I just want you to get help.
Yes, sir.
Heroin is a vicious, vicious drug.
It is, and I lost my stepbrother to it 2 years ago. My stepmom found him overdosed in his bed, and September last year, when the cops came to my house to help me, that's when they found my syringes full of heroin, and I had overdosed. And
Austin, if you want to, we just want you around for a while, and that
yes,
means
sir. And I want to be. I've been sober ever since. I went to rehab, and
Okay.
I'm doing really well. And
don't do me wrong on this one. Show up for court and don't take drugs anymore. Please.
you have my word, Your Honor. I don't want to do drugs anymore. I've got way too much to live for, you know.
Well, we all have our addictions, as you can probably tell. Mine is food, but and the problem is, just like food, these addictions don't go away immediately. It's going to be a lifelong struggle, but we got to stay on top of them, right?
Yes, sir. Do I need to put I am indigent?
No, because I'm letting you out on a personal bond. Initials on the top.
Oh.
Come in.
Right here? Okay. And yes, I I'm very glad to be sober. I've been sober since October last year, and I'm glad to be sober. And I don't want to be I've lost almost 40 friends to drug addiction, and I don't want to be another one of those numbers. You know.
I don't want you to be either. So let's just
Okay.
take care of business.
Yes,
Okay?
sir. Thank you so much.
All right.
Will I get one of those pieces of paper?
They'll work on it. It's still going to take them a couple hours to do that. Okay?
Okay. Thank you.
Brittany Liesk?
Pretty less, sir?
Yes.
Okay.
Brittany, it's a charge out of Cook County, warrant 66709 for possession of controlled substance in group 3, under 28 grams in amount. It would be in addition to your other cases out of Cook County. So they have a possession of controlled substance in group 1 at 5,000. Possession of controlled substance less than 200 grams at 20,000. And now this one's been added, possession of controlled substance in group 3, under 20 grams in amount. They left it up to me, which I'm sure I set much lower bonds than they do in Cook County. So it's only at 1,000.
Yes, sir.
So it brings your total then up to $26,000 in bonds. So I'd say it still costs you around $2,500 to get you out through a bondsman, but they're theoretically bondable. So let me get your signature on this form, just saying you understand rights, charge, and bond, not saying you agree with it.
Yes, sir. I have a question. The $5,000 bond, I got brought in here on an over 4 under 200 for a warrant for Cook County, and you set it at 5,000, and then that Friday I got brought back in here and got arraigned again because I got indicted, and that's why I got 20,000. Do you know why it's still showing 2 separate charges?
No, but if we'll confirm so to take one off. And I'm just looking at the back of the book, and so that could have already been updated. But yeah, they put those on there when they're put in. So we'll check on that and see.
Yes, sir. Because I asked you, and you said that it's just one. Because I was kind
Yeah,
of
they obviously thought my bond was too low, didn't they?
Yeah. Yes, they put 20,000, but
Well, I guess we have to look at it in a positive light. That means that they think you're worth a lot more money than I did, right?
yeah, definitely but they have still left me here. So I mean, they haven't came got me. They stuck me here.
So they love you. They don't just love you enough, right?
Yeah, no, they don't want to share their baloney, I guess.
Okay. So do you have a court-appointed attorney up there?
For another pending charge, yes, I do.
Let's put your initial, is it court-appointed, the initials in that bottom box saying we need to notify them that you need court-appointed counsel.
Okay. Okay. You will check on, make sure that it's just one over 400, 200, sir?
Yes.
Thank you, I appreciate that.
Ryan Dingman.
Yeah.
Let's see, Mr. Dingman, they have you here on a charge of assault, family violence out of Double Oak. Bonds at 5,000. So again, a bondsman typically run you about $500, depending on the bondsman, sometimes a little bit less, but it really depends on whatever you can work out with them. Statement of all your constitutional rights, one charge of assault, family violence. I guess it was alleged with your father. So let me get your signature on that line, just saying you understand your rights, your charge, and your bond.
What if I don't pay it? Do I ever get out?
Yes, you would eventually would get out, but you wouldn't get out as soon as you could. All right. And do you have an attorney on this case? Oh, well, you don't yet. Are you going to be able to post that bond?
No,
Huh?
no.
Let's try it. Let me get your initials in that bottom box right above your signature saying you're claimed to be indigent, need court-appointed counsel. And there is a protective order that's going to be in place. It says that for the next 61 days, you cannot go home. You can't call, threaten. You can call, but don't do so or make any statements that might be a threat. So be careful what you say, but no matter what, even if dad says you can come home, you cannot go to the home located at, what's the address? It's in Double Oak, so, where is it? So you cannot go within 500 feet of 6015 Plantation Lane in Double Oak, Texas for the next 61 days, okay? Let me get your signature on the bottom of that saying you understand you cannot go home. Even if dad says you can come home for the next 61 days, 2 months, you cannot go home. If you go home, you're subject to arrest on a whole new charge of violation of protective order. All right, we'll give you a copy of this and then you can go try to work on your bond, okay?
I guess I'll just stay in here. I mean,
Okay.
unless I can leave.
Let's try to get you a court-appointed lawyer. So did you give me your initials in that bottom box saying you need court-appointed counsel?
Yes, sir.
Okay. We'll try to get you an attorney, see if the attorney can work on something else with it, okay? All right, have a seat. All right, folks, go work on your bonds. Hopefully they can get you out. If you don't have bond, we'll see if we can get you an attorney, get a bond set for you, okay? Yes, ma'am?
If we have two more, we have Hill and Quan, I'm sorry. I'll take you back with them.
Okay, thanks. Are we done?
No, we have two more, Judge.
What?
Hill and Quan.
I have a 3 o'clock meeting. But yeah, sure, why not? Did I skip over some or something?
They're the top two, Judge.
So I must have skipped over them. Oh, I guess it's because we got started on Carter, I guess that's what. Dylan Hill. Mr. Hill, let's see. Charge of possession controlled substance pen group 1 under 1 grand round, but it is a probation violation out of Grayson County. So only the court that issued the warrant for your arrest and the court in which the case is pending out of Grayson County can set bond. Grayson County warrant 071082 has no bond currently. Doesn't mean you can't get bond set, but you would have to have your attorney in Grayson County go talk to the court, see if they can do that. So let me get your signature on that form, just saying I told you about this no bond status currently. And do you have an attorney in Grayson County? You do? Is it court-appointed attorney or one that you've hired?
I don't believe so, Your Honor. I don't know if I have one or not.
Let's go ahead and ask Grayson County to appoint you an attorney. So initials in that bottom box saying you're claimed to be indigent. So we'll notify both Dallas County and Grayson County that you're in need of court-appointed counsel, so we can try to get that taken care of, okay? All right, thank you. And Mia Kwan. Ms. Kwan, looks like they've added one, actually 1, 2, 3, 4, 5. Charge of possession of marijuana under 2 ounces amount of failure to appear. County Criminal Court number 1, CR 20-018 03487-A, bond at $4,002, but it's bondable. 2, possession of controlled substance, both out of the 462nd District Court, F18 686-211 and 689-211. No bond currently. Again, you can get the judge of that court, Judge Shanklin, to set bond, possibly. Charge of assault causing bodily injury, also a failure to appear out of County Criminal Court number 1, Judge Ragland's Court, CR 2018-00655-A at $10,002. And one more probation violation for DWI out of Travis County, down in Austin, CR 1920963, bond at $6,500. So once you get bond set in here in Denton County, you can post bond on all of them here, be released from here, but eventually you're gonna have to show up both in Denton and Travis counties. So without saying you agree with any of those charges, just you understand that information. Let me get your signature on that line, just saying you do understand rights, charge, and bond. And then let's try to get you a court-appointed attorney if you don't already have one. Do you have an attorney already?
Yes, I have an attorney.
Is it court-appointed when you hired?
He's hired.
Initials in the top box saying you're not claiming to be indigent currently. And then,
I was asking if I can get like a copy about, so I could, how do I know how much my bonds are and everything?
well, it'll be on the system. So if someone wants to call, they can look at that, or if you call the bondsman, but until you get those two bonds set here in Denton County, it's not going to do you any good. Okay.
Okay, how much did you say the Travis County one was?
Travis County is for $6,500, kind of an odd amount.
Okay,
Yeah.
okay,
Okay.
thank you.
All right. Thank you.
All right, Karen.